And so I think the, the regulatory, or that's the wrong word, but the legal process for holding people account is the malpractice law. Can we sue for legal malpractice, a sandbox entrance where the service is being provided by mostly a computer or mostly a social worker? And the answer is yes, you can sue anybody. And if you sue them, what are you going to be required to prove? That the social worker gave you lawyer quality help in figuring out your domestic violence restraining order form, or that the computer gave you lawyer quality, and again, we're talking minimum lawyer quality, but sort of at least not malpractice level assistance in drawing up that will. So I think of it as being a standard that we perhaps want to adopt for the applicants, but not that we intend to enforce by regulation, because how do you do that? But that gets enforced by the market, but by a market fortified with legal remedies to go after bad actors and bring them down and chase them out if they can't meet lawyer standard for whatever the services that they're providing. And it may just be filling out forms, which, most lawyers provide a broader range of service. But where the service just is filling out the form, are you at least doing a lawyer quality version of helping an applicant fill out a form? So that, I just wanted to offer that in response, but I took myself out of turn and I apologize. Ms. Sandifer.
I just wanted to make a couple of observations. So one thing that I've heard and that I'm hearing here is sort of I love food, obviously. So to stick with the food and drug analogy, are we the FDA where we have a large evidence base about what the current effective standard of care is, and we can compare the new thing to that? I don't think we are. I don't think we have that evidence base. So we don't have the knowledge capacity to act like the FDA. So I think practically we have to act more like the county health department and make sure the food isn't rotten. That's sort of the level of capacity that we have. I think to the issue of competence, as a consumer, I absolutely don't want to buy incompetent stuff. The way that the Utah model approaches competence is by the harms that incompetence creates. So those of the three things that could go wrong in that framework, two of them are because the provider is an idiot, right? So the provider gives you bad advice, or the provider does things that screw up your issue. And that's a way of monitoring for competence on the back end without trying to figure out what competence would look like from the front. That's all, just those perspectives.
Mr. Rothschild, and then Ms. Liberty.
Two thoughts. First of all, I think that Justice Tucher was right that we were not looking at a precondition of competence, but that be an issue that's addressed in the application, and that it be measured by seeing the outcomes, and are they competent outcomes. On the issue of letting the market decide, that always bothers me in these kinds of situations. If I go into the supermarket and I get rotten meat, I'm not going to go back to that supermarket next week. If I need a divorce once in my lifetime, the fact that it gets screwed up doesn't mean that the next person isn't going to have the same problem. I'm not in a regular market kind of situation. I don't know how the market regulates single time. And our economists can answer that better than I can. But I'm concerned about how, if I'm walking in cold to somebody, because they've got a sticker on their door that says I'm regulated, even if I decide I'm never going back there, I'm probably never getting another divorce. So that doesn't really help.
Thank you. Ms. Liberty.
Thank you. Just a couple of thoughts. One is with respect to competency. I think if we don't define or set a pretty high standard for the competency requirements, we're going to have a heck of a time getting anything through the legislature. I think I have a fairly good sense of how the legislature views the state bar and views statutory changes related to the State Bar Act. I've lobbied them. I've also sued them several times. So I have a little bit of insight. So I think we should be mindful of what their reaction is going to be if we are not setting a pretty high bar in that regard. With respect to, I really like the analogy about the FDA and the county health commission or department or whatever you said, Professor. I also think we need to be mindful that we are a committee of the State Bar of California, which regulates lawyer practice and takes away lawyer licenses when they violate the rules. So we've got to have an eye towards, it should be some sort of do no harm standard at its basis. Those are my thoughts.
Thank you. Mr. Helland.
I just wanted to accept Toby's challenge. So one thought would be, and I'm sort of kidding, but I actually think maybe this feeds into the transparency part, which is, does the Sandbox, sort of make public complaints or some measure of complaints? And so I think there is a discussion here, because you're absolutely right. You don't buy divorce services, but we have many other goods in the economy you don't, sort of buy as frequently as you buy groceries. And I think the way we deal with that is to try to have some sort of disclosure around that. That could be private or it could be the entity. So I just wanted to flag that at some point, as we have the transparency conversation, it may be that we want some of this data to be public, that what the complaints are, in a way, for example, that complaints against professionals are public.
Mr. Arruda.
My comment's quite quick. I think one thing that I always try to shy away from, and I guess I'll just put it to the group, and it's more of just an observation, is sometimes it's tough to write things as it pertains to what the legislature is going to do, because then it becomes an exercise of not what we all collectively agree is the best path forward, but whatever we think is the most likely to get voted through or passed politically. So I think it's always a slippery slope, because I always like to just stand up and say, this is what I think is right. This is what I think should happen, regardless of the politics or any of the things in the background of the likelihood of success. Because I think ultimately what we are also doing with, as a group here, is providing a historical artifact, and all of us will be judged on what we all do by the generations to come in the future, looking back on it. So I'd rather, for the record, state what's an accurate picture of what we believe to be right, wrong, and what we want to accomplish.
Thank you. Ms. Sandifer. You're on
Sorry, bad protocol.
mute. Does that mean you don't have a
Bad
comment?
protocol. Hand was not up.
Okay.
I don't have a
Mr.
comment.
Rothschild, did you
Sorry.
hand up intentionally? Toby, Mr. Rothschild? No, not up intentionally. Okay, then we may be ready to move on. I think there's still a couple of sections of this report we haven't addressed yet. We don't have much time left, but you want to give us a...
Sure, but Justice Tucher, do you want to have a vote on this competency question, or do you want to just us kind of take our impressions from this conversation, or?
Well,
How
let's
easy
see,
is
what would the vote be? It would be a straw poll as to whether or not Sandbox participants should be held to the standard of lawyers in the provision of the services they're going to offer. So we wouldn't be voting on how that's going to be done, whether we're talking only about tort
Right.
law after the fact or some showing in the application process. It's just, do you think the standard for these service providers should be the minimal legal competence of a lawyer? Or do you think that there's some acceptable, I think I would have to say lower standard that the applicants can be held to?
I think a straw poll would be helpful.
Okay,
Becky, what do you think?
let's do a straw poll. Is there anybody who
Yeah.
finds those two options unclear? I think I'll call them lawyer standard and lesser standard for ease of use. And given the shortness of time, I'm going to try not to have discussion about the structure of the poll. If you can't vote for lawyer standard or lesser standard, tell us why not in a sentence or two when your name is called. So let's vote.
All right. Okay, we'll start with Marta Alcumbrac. How about we just go with same or less, just so that, to make it easy. So same standard as lawyers, less standard. So same or less, Marta. Did you say same? Okay, sorry. Andrew Arruda,
Less.
Merri Baldwin,
Same.
Judge Wendy Chang,
Same.
David Engstrom,
Less.
Bridget Grammy, Tom Green,
Same.
Dan Grunfeld,
Same.
Eric Helland,
Less.
Michael Star Liberty,
Same.
John Lund.
Different and determined by the market.
Okay, Kevin Mohr,
Kevin, you're on mute.
I apologize. Same.
Toby Rothschild,
Same.
Rebecca Sandifer,
I'll take John's term, different.
Jim Sandman,
John Lund.
okay, Patricia Scutiera.
Same.
Okay, thank you. Do you want to know the poll on the numbers? Or Justice Tucher, do you have input?
Same.
Okay, so 4, 5, 6, 7, 8, 9, 10, 3, and 3 difference.
Got it. Okay, that's very helpful. Thank you.
Good, and I hope, is somebody from the John Lund School on the scope committee? If not, I think we should get some further elaboration so that as you go back, you know. For those who want something different from the same.
I think I'm seeing some votes change in the chats, or potentially changing.
Ah.
Yeah, I think
Two people who say, well, they'd be happy to characterize themselves as the Lund standard. So would somebody who's characterizing yourselves as the Lund standard, whether your last name is or is not Lund, like to say what you think the standard should be? Or put another way, when I get the legal malpractice case, well, not me, Wendy Chang, someone in the Superior Court who's going to have to write jury instructions, who gets a legal malpractice case against an alternate service provider who is not a member of the bar, what standard should the jury be told that this provider has to meet?
Well, now you're throwing it up in a very difficult question, Justice Tucher, which is, I'm sure, your job, but I think it's focusing on liability down the road and not on what the market's doing. And my concept here is to say to people, it has to be just as good as what a lawyer would give you, is A, not necessarily what people want to pay for, and B, maybe not what they actually want. They don't actually want the level. So there is some articulation in there of good enough and worth my money that maybe is sufficient. And by the way, good enough, worth my money, and isn't causing me harm. And so I think to raise the bar to be as good as a lawyer is to create a real impediment to meaningful innovation.
That sounds like a balancing test.
Okay, Mr. Helland, and then Ms. Alcumbrac.
This is actually a question as one of the few non-lawyers on this committee. Wouldn't it just be harm? I mean, if it came before Judge Chang's court and you had actually, sort of given me a divorce advice and that turned out to sort of make me worse, wouldn't that be my lawsuit just as a products liability or something like that? I wonder if the answer to that question isn't sort of already an existing law. And I could be totally wrong about that.
Well, it's in existing law for lawyers because when you sue a lawyer for doing bad work on your divorce, the standard is the minimum legal, the minimum requirement for lawyers. And the jury has to decide what a minimally competent lawyer would do. Presumably leaving one of your 3 kids out of the custody agreement would not be minimally competent, but the standard roughly is minimum competence of a lawyer, the community practice standard. So we're authorizing people who aren't lawyers to practice law in the sandbox. So the question is, should they be judged by that standard or should they be judged by a different standard? Mr. Mohr, and I guess I said Ms. Alcumbrac and then Mr. Mohr.
Well, thank you for your explanation of the, kind of the C standard of the minimal competency of a lawyer when you sue one for legal malpractice. And it is a general tort negligence lawsuit, and whether or not that attorney breached that standard of care. But, perhaps I got a little lost in the Lund standard. So can we have an explanation? Because I didn't catch Lund, and I'd love a jury instruction on that, as a matter of fact, too, because that could be fun.
Yeah, I mean, I think conceptually one of the things that's going on here, remember that Lucy and James talked about shifting from regulating roles to regulating entities. And this is about, any business that's got a responsible obligation to provide a responsible level of service. We have consumer sales practices protections. We have lots of standards out there that any business needs to follow. And I guess I am concerned here, not so much with the specifics of how that's worded, because of what Eric notes, that if you make the mistake, you make the mistake. At some level, this lawyer standard thing is something that people like Merri Baldwin do a great job of using to defend lawyers, right? Because there's this standard of care requirement where I think that Eric's question shows us that really, if the service was bad or the service was wrong, that's the answer. It's not about some articulated level of care or reasonable care under the circumstances. It's, you didn't do what you promised me you were going to do. It's more of a contractual level of you didn't perform. And I'm not sure, Marta, that I can do better than that to spell that out.
Thank you.
Okay, thank you. Mr. Mohr.
Yeah, I just want to point something out, that the standard in the rules of professional conduct is a little bit different than what we've been talking about. And I also want to address the issue that Toby raised about what happens if I only have one divorce in my life and the lawyer screwed up. Okay, divorce, it might be worth it to sue the person who provided those services or the entity that provided those services, because the injury that was suffered is going to might have resulted in substantial damages. But what are we talking about here? We're mostly talking about, I think, we're talking about affordable legal services, and that each legal service provided isn't necessarily going to amount to that much. So when we start talking about this concept of malpractice or suing someone going into court, jury instruction, it's not going to happen. It generally, because it just wouldn't be worth it to try to do that. But if you look at the standard of conduct for discipline for lawyers, one mistake isn't going to be enough for you to be disciplined, because we all make mistakes. I admit it, all right? I think that most lawyers here will admit that at some point you made a mistake. So what's required? It has to be a repeated mistakes. It has to be intentional. It has to be reckless or with gross negligence. That's the standard. So if that's what we're concerned about, let's get the people who have made repeated mistakes out. Maybe we should have a standard like this. It's a little bit late. We only have about a minute and a half at this point before we end, but I'd like to maybe revisit the competency question in this scope subcommittee and come back to the full working group later, in June at our next meeting. But right now, I think we need to consider what do we want to accomplish by setting a competence standard? Is it to get the bad players out of the market? Or do we just want to be able to sue those bad players for whatever they're worth? That's all I have to say.
Well, thank you. Judge
quickly
Chang, you
add-
may have the last word. Go ahead.
Yeah, before we go, I just think it's a mistake to think that a lawsuit is actually a real, always a viable option, because there's plenty of lawsuits that lawyers will not take. And I get plaintiffs who come into my courtroom trying to pursue their rights, and they have no lawyer, and they lose their case because they get completely lost in the process. So when you start thinking about what available remedies are, not every lawyer will take every case out there that has a just reason, because there's got to be a business reason for a lawyer to take it, or they don't take it most of the time.
That circles us back nicely to where we began. There is a justice gap in California. Our work is to see what we can do to close the justice gap by promoting innovative provision of legal services. So thank you all for the hard work you all have done to be ready for today's meeting and to participate freely and I think really productively in today's meeting. And we know what we need to do next. The task forces are going out to continue the hard work, and we will see everybody in June. Thanks, bye.